Victoria v. Commonwealth, 45 Australian Law Journal, 251 and Amalga 14D Society of Engineers v. Adelaide Suam Ship Co. Ltd. 920. 28, CLR 129, referred to Queen v. Bura, 1878, 3 AC 889, held inapplicable McCulloch v. Marilanil 1819, 4 Wheaton 369, Essendon Corporation v. Krilrian Theatres 1947-74, CLR 1922 in State of West Bengal, Union through India, AIR 1963, SC 1241, referred to Vachern Sons v. London Society of Compositors, 1913 AC 107 at Piaido, London 21 128, Bank of Totonto Vilambe, 1887 12 AC, 575 586 as part Crossman, 267, US 120 12 referred to appreciate the argument that there is inherent limitation on the power of Parliament to amend fundamental rights at NCC Osiri to understand the source from which these rights arise and the reason for their fundamentalness. Natural rights are those rights which are appropriate to man as a rational and moral being, and which are necessary for a God life. Although called rights, they are per se enforceable in courts unless recognized by the positive law of a state. The word right has to be reserved for those claims ailed and protected by law. There are rights which inhere in human beings they are human beings. Whether you call them natural rights or by LLL other appellation is immaterial. As the preamble indicates, it was to the basic human rights. KC liberty and equality that the people gave. Thetans. Yes, the Constitution and these basic rights are an essential feature of the Constitution. The Constitution was also enacted by the people to Kirk Gelisteel, political, Oshaland, economic. Therefore, the moral rights cited in Part 4 of the Constitution are equally an essential feature of it. The only 64 Supai MJCOUJ, T. Leopold's 1973 Supes, CJL differs being that the moral rights embodied in Part 4 are not specifically enforceable as against the state by a citizen in a court of law in case the state fails, implement its duty, but nevertheless they are fundamental in the governance of the country, and all the organs of the state, including the judiciary, are bound to enforce loose directives. The fundamental rights themselves have no fixed content. Most of them are mere empty vessels into which each generation must pour its content in the light of its critics, restriction, abridgment, curtailment, and even abrogati 90 of these rights in circumstanza, not visualized by the Constitution makers Mitexco MC, NCCC, SERI. Their claim to supremacy or priority is liable to be overborne at particular stages in the history of the nation by the moral claims embodied in Part 4, whether at a particular moment in the history of the nation, a particular fundamental right should have priority over the moral claim embodied in Part 4 or MWT yield to them is a matter which must be left to BC, decided by each gen Krakioa in the light of its experience and its values. And if Parliament, in its Capicil J as the amending body, decides to amend the Constitution in such a way, to take away or abridge a fundamental right, to give priority value to D, immoral claims embodied in Part 4 of the Constitution, the court cannot adjudge the constitutional amendment as bad for the reason that what was intended to be subsidiary by the Constitution makers has been made dominant. Judicial review of a constitutional amendment, for the reason that it gives priority value to the moral claims embodied in Part 4 over the fundamental rights embodied in Part 3 IJ, impermissible. Many of the Article J, whether IA Part the 3rd or Part 4, represent moral rights which they have recognized inherent in every human being in this country, taking for granted that, and large fundamental rights are the extensions, permutations, and combinations of natural rights in the sense explained. FT docs not follow that then. Kanu any inherent limitation by virtue of their origin or character in their BCians taken away or abridged for the common good, the source from which to BO rights derive their moral sanction and transcendental character, namely is natural law, itself recognizes that natural rights are only prim 11 fadrip, liable to be taken away or limited in special circumstances for securing higher values in a society or for its common good, but the responsibility all. Parliament in taking away or abridging a fundamental right is an awomo one. And whenever a question of constitutional amendment which will have the above effect comes up for consideration, Parliament do to be aware this they are the guardians of the rights and liberties of the people in a 2ius degree than the courts, as the courts cannot go into the validity O1 DIO amendment on any substantive ground, 814 to 836. State of West Bengal v. Subodgopa J. 1954. SCR 58I. 596. Bush is near Nath v. Commission of Jammu. Tar Delhi, 1959, Sup 1 SCR. 526 State of Murasv. Hamnelkam 1025 SCR 525 Rom at TNFM Jam.